while she's getting connected, last week one of you guys asked a question about wills, how they work, how it should set up. Hey, Krista, how are you?
I'm good. How are you?
Good. I was just giving a brief introduction about how we got here. One of my followers last week asked a question about wills, and I was able to talk about kind of our personal experience with wills, but I am by no means an expert. And Krista at Estate Planning Mom is, and she very generously offered to hop on live and answer a bunch of the questions that you submitted. So this is Krista. She's at Estate Planning Mom for all of you guys that are watching and listening. And maybe just to get started, you could tell us a little bit about your background and what you do.
Yeah, absolutely. So again, my name is Krista Hermans. I am an estate planning attorney, and I am licensed to practice in California. So all of the stuff that I'm going to be talking about today is state specific to California because that is the law that I know. So anything that I talk about on here, if you're not in California, it might be general information, but definitely follow up with an attorney in your state to make sure that it's relevant to you. So I have my own practice. It's Hermans Law. We have a team of 7 women, they're moms, that are on the team. And we really focus on families that have minor children. So it's really making sure that parents know all of the things that they can do to have a plan in place and to protect their kids. And I am located in Ventura, so okay. But we service clients all throughout California. So it's we just started doing virtual appointments with people, and it's going really well.
Very cool.
Yeah.
So maybe I know there's like a wide range of options that can happen when you're setting up a will. What are the basic documents that you should complete as part of that process, kind of maybe at the most basic level? And then I know there's kind of more advanced stages too.
Yeah, so from, again, California, because some states don't do estate planning in the same sense that we do. We are very driven on trust-based planning in California, and I kind of want to clear up that misconception with wills because I think a lot of people don't really have that understanding. So essentially a will is basically just a document that when somebody passes away, the will is filed with the court, like probate court, and all a will says is basically how you want your stuff distributed to your beneficiaries, like your kids or your family, and guardians for your kids. So a will is still filed with the probate court. It doesn't prevent going to probate court. And a lot of people think, well, I have a will, so it doesn't really matter. You know, I'm covered in that sense. And that's just not true, right? All a will does is it says where you want your stuff distributed, where if you don't have a will, the court then determines how it's distributed. So from a trust perspective, which is really the planning that I do for families, because I feel like it provides the most control to the parents to be able to say how they want their stuff to be distributed to their kids if something were to happen. So this is a trust binder here, okay? It's a very thick document, but it has a ton of important stuff that I feel is very important from a planning perspective when families have minor children. And what an estate plan would include is a revocable living trust, okay? And basically what that document is, it's a very large document, but it's basically instructions provided by the people who create it, the grantors, where they give instructions to the trustee, which is the person who agrees to hold legal title to the assets in your trust. And those are instructions for the benefit of your beneficiaries. Now, while you are alive, you're the grantor, you're the trustee, and you're the beneficiary. So you're not losing any control of the assets that you have. You're just putting them in the name of your trust that you control. And what the trust allows you to do is have those assets in trust so that if something were to happen, those assets are in your trust. They wouldn't have to go through probate court, so it's avoiding probate. And what it also allows you to do is say how you want your stuff distributed if something were to happen. And so that's one reason I really like trust planning for parents, because if something were to happen to you and your spouse, then you can say, well, if something happened and we had our life insurance and our retirement accounts and our house in the name of our trust, we want our children to receive it at 25, 30, and 35, rather than it going to them through probate court, which they would get when they turned 18 years old. All of it in one lump sum.
Does a will automatically go through probate court, or only if it's contested in some way?
No. Every will is going to go through probate court. It does not prevent. All the will is doing is saying how you want your stuff distributed.
Okay.
but it still has to go through probate court to go through the process, where a trust avoids probate generally.
Okay. And one of the questions we got from a couple different people was, how should you think about and who should you choose to be your, and I think you use the term trustee or executor, or
they're all kind of the same.
And instead of, it's going to be you or your spouse in the event that one of you is surviving, but then how do you choose who that next person is?
Yeah, so it doesn't have to be your spouse. It's generally what people would want, right? That's generally what they choose. But so there's different types of agents that you would want to choose. And you kind of mentioned the executor, the trustee. That's the person who manages the trust or your will. But then there's other documents, which would be a power of attorney. Okay, and that's durable power of attorney. That's for somebody to make to make financial decisions on your behalf. And then we have an advanced healthcare directive. Some people know that as a living will, and that's where somebody would make healthcare decisions on your behalf if you were incapacitated. And those documents, honestly, they're very different roles, right? Because you have somebody that is great with money and organized and can go in and, pay the mortgage, file tax returns, do any of that stuff from a power of attorney perspective. So that might be somebody that, it could be a family person, right? It could be somebody that you're related to, or it could be a friend that is very responsible and that you would trust to be able to manage your assets. So from the advanced healthcare side, that one is really more of who would you want to be able to make healthcare decisions. And I find with clients, it might not be the same as their trustee. So it might be parents. Sometimes parents, they don't think would be able to make the decision. So it might be siblings, or it could be friends. So it really determines who you have in your circle that you think would be good at making those decisions, especially for the different types of documents. And those two documents that I just mentioned, those I really do believe should be included in a full estate plan. So the power of attorney, advanced healthcare directive, HIPAA authorization, allowing people to talk to doctors, get medical records.
Okay. And that goes along with kind of when we talked about all the documents to be completed. So far, we talked about the revocable living trust, which is kind of your part of the estate plan and puts it in a trust separate. Is there also a will separate from that?
Yeah, so when you have a revocable living trust, you'll have what's known as a pour-over will.
Okay.
And the pour-over will essentially is something that isn't going to have all of the same type of information that a regular will would have, but it basically says if something gets left out of your account, or left out of your trust, or maybe there's a lawsuit after you pass away, anything then is poured over essentially into your trust if it has to go through probate.
Okay.
You don't want to live big things out of your
right.
trust, like a house, right? Because that's a big asset. It can be moved in, but it takes a little bit more probate work. And the biggest thing with avoiding probate is very expensive. Mm-hmm. It takes a very long time to go through. So in California, it could take anywhere from 1 to 2 years, sometimes more if it's contested. And it's completely public. So anybody can go down to the courthouse, pull any type of public records and see exactly what assets you have, what debts you have, and who's getting your stuff.
Okay. So it's definitely a privacy issue.
Absolutely.
Once you complete your binder, what should you do with it?
So that's a good question. I tell clients that you need to keep it somewhere safe, that your trustee, the person that you've identified to handle if something were to happen to you, needs to know where it is. Some clients like to actually send them a copy. So I provide everything to my clients on a USB drive, and I scan, so it's scanned, all the documents are scanned. So I tell them, put it somewhere up in the cloud, put it somewhere safe so that you have a scanned version of it. And then if you are going to lock it up, because some people do like to keep it in their safe, you need to make sure that people have access to it, right? So that your trustee or your executor know where it is. Because that's one of the issues that we see a lot with older people is they have documents, but nobody knows where they are. They can't find them, or they're in a safety deposit box that nobody can access. So then they have to go to court to get the rights to open it.
Yeah.
So it's definitely making sure that you keep it somewhere where somebody knows how to access it, especially in an emergency.
And then how often should you be updating it? I know you mentioned, obviously, you don't want to leave big things out. So what are the things or events in your life that would trigger you needing to update your will?
So
or your
I tell
trust?
So I tell clients every 2 to 3 years, and I actually do a review with them every 3 years. It's included in the package that I do with clients. And besides, and during that review, we'll look at, who do you have identified as the agents? Who are the guardians? Is everybody still in good health, right? So if a life event happens where somebody that's listed as one of the roles in your estate plan passes away, or maybe has Alzheimer's, or something where they don't have the capacity to still serve in the position you've identified, then you need to update it immediately, right? In addition to that, if you have another child, whether it be legally or through natural childbirth, make sure that your plan is updated with the new children's information, or to make sure that the plan actually will allow more children without having to name them. So I do that a lot with clients, because most of the clients that I work with are young families. So, that's one of the things I ask is, are you going to have more children? Because then I'll draft the trust in a way to make sure that rather than naming children specifically in the trust, it will say all of my children shared equally, so that they don't have to update it if they're going to keep having more kids.
I think that's what we did.
Yeah.
I'm pretty sure that's what we did. So then we talked a little bit about some of these, but I think we've already addressed the difference between a will, a living trust, and a trust, and how do you know which ones you should have? So is there anything else beyond that where
No, I think those are the main things. And generally with clients that I'm working with, I would steer away from the will-based planning. Again, I'm in California.
Yep.
Because the trust, when you have kids, when you have minor children, it's going to allow you to plan so much more for them. Also, it allows you to have plans if there was an incapacity, right? Mm-hmm. And will-based plans, those only take effect when somebody passes away.
Right.
So once those are filed with the probate court, whereas the trust, that plans for incapacity, it plans for anything that you're doing. If someone were to pass away, to be able to make sure that the children are cared for. And again, that's our biggest thing, right, within our practice.
And then one of the big questions, and I'm sure this varies depending on where you live and the package involved, is cost. Yeah. What should something like this cost, and how can families do it in a way that's affordable?
Okay, so it's going to be very widespread because of the different areas. So I think like will-based plans, maybe starting at about $1,500. If they're less than that, I would be cautious just to make sure it includes everything that you need. And then, plans like here in California, they'll go up to $6,000 to $10,000. It really depends on the type of plan you have. Like the very basic plan is going to be something that has a sub-trust, where you're giving to your kids at 25, 30, and 35, where more advanced planning is going to be something that's going to get into, like asset protections, where you're setting up lifetime asset protection trusts for the children so that they're not getting those distribution at ages, but rather keeping it in a lifetime asset protection trust to be able to, prevent them from money getting taken away from future potential ex-spouses, from creditors, from predators, or maybe even from themselves if they have like a drug or alcohol problem.
And maybe just talk a little bit about what's involved in setting up a trust. Part of the reason it is more expensive is because you are getting a lot more protection, but you're actually creating like a whole legal entity, right? When you're establishing a trust.
So it's almost like its own legal entity, but while you are alive, all of the stuff is yours. So you're not like losing any control of the stuff. But when somebody passes away, it does get its own EIN number. So while you're alive, it's through your Social Security number. It's only once somebody passes away that an EIN number would be created for it. But the process for us for creating a trust is we have what's called a family planning assessment, where clients will come in and they fill out a questionnaire online beforehand. And what we're gonna look at is what family do you have, what assets do you have, and then we're gonna do an assessment. If something happened to you today, what would happen to your stuff, and what would happen to your children? And then from there, if they don't like what would happen, we design a plan for them in that meeting that essentially resolves all of those issues. Our process is generally about 4 weeks. And so from the time that they design their plan, we get started working on drafting it We'll communicate that with them. We have secure client portals that we use, getting information, getting contact information for all of the guardians and the agents and things like that. We send it to them to some documents to review. And then about 4 weeks after from the start of it, we sign all of the documents. We do a witnessing and signing ceremony, and then everything is done at that point, right? They've signed all of the documents. Only thing after that, and which is so important, is once you have a trust set up, you need to make sure you fund the trust. So when I say funding, I mean moving your assets into the trust, because a trust that doesn't have any assets to distribute doesn't have anything to care for your children. Right? Okay. If you don't have your house in the trust, that still would have to go through probate. The same thing with life insurance proceeds. If something happened to both parents, and those life insurance proceeds were just had the parents listed as the beneficiaries on each other's, that money would still have to go through probate court to get to the kids.
So you're then changing all of all the beneficiaries to your trust.
At least, and it's on a case-by-case basis, so it's more of just generally, especially for young families. A lot of times clients like to have the spouses as the beneficiaries, in the first position, and then they'll list the trust as the alternate, so that if something happened to both spouses, the money would then go into the trust. And there are different types of trusts. So like revocable living trust, there's irrevocable living trust, retirement trust, life insurance trust. So there are different types, but that gets into a little more advanced planning. Yep. Most of the families that I'm dealing with, this is their first time doing planning, and this is really all that they need to get started, is a revocable living trust.
So I had some people ask about, why should you use an attorney over like a website? And I think just everything you walk through in terms of why you want to have a trust as opposed to just a simple document that's a will may kind of address that question. Is there an asset level or an income level where, it doesn't make sense to set up a trust? Like, or if you have children, this is the way you should do it?
Yeah.
Okay.
So any client that comes in, if they have kids, I recommend a trust. And I have clients that don't own homes, but they have life insurance, right? They have a little bit of money in the bank. So they wouldn't want that life insurance going to the kid when they turn 18.
Right.
So just to talk on the legal document sites, I actually have 2 comments on those. So I haven't used them. I have no idea, what it's like to actually draft documents, but I have gotten feedback from clients that have worked with me after they had used them. One of them was they had purchased the documents to do the trust, and it was too overwhelming. They didn't know what to do, and they didn't finish it. So they purchased it and then came to me to do a trust for them. Yep. So that was one thing. And then the second one was somebody very recently where the documents that they brought to me because they were going on vacation, and they needed something because they wanted to, and it happens all the time. People are leaving. They're like, I don't have anything in place. So I was reviewing the documents, and in the guardianship paragraph, it started out nominating guardians, and then somehow in the middle of the paragraph, it started nominating conservators for them. So it had switched the language where it wasn't even nominating guardians anymore as alternates. It was now nominating conservators for them. So it's just, they didn't know that. I mean, just me reading it, I was looking at the language. I was like, I don't know how this happened.
Right. But we're not lawyers. There's a reason you consult a lawyer.
Yeah, exactly.
So we have a few other questions that have come in just while we're talking. Someone asked, how do you recommend clients consider philanthropy in their trusts? That may be more advanced, but...
No, so there's a couple different ways to do that. So in the trust drafting meeting that we have, in that design meeting, clients have the option of doing what's called a specific gift. So depending on how much money you have, if something were to happen to you and your spouse, if you have minor kids, you might not want to give any of your money, right? You want that all going to your kids. But if you have more that you want to give, so I have people that have charities that they're very involved in, or churches, they'll actually say, I want to give this specific dollar amount or a specific percentage of my estate to this charity, okay, or this church. So that's one way to do it. Another one, is you can just name a charity or, church as a beneficiary, right? Just to receive it in addition to that. It's just a matter of how much money you have. Because again, a lot of my clients, they have young children, and their biggest focus is making sure that the kids have enough money.
And that's definitely most of the people listening here too. They're, they're moms, they're young families, and they're looking to do what's going to protect their family. So here's another one. What if you need to update your living trust will, but don't want to use the same attorney?
So any attorney should be able to do an amendment or a restatement of your trust. So you can take it to anybody, let them see a copy of it, and have them review it and just say, this is my situation now. What needs to be changed?
Okay.
So it doesn't have to be the same person that drafted it.
Okay, so those were the only additional ones since we started. Is there anything else you would want people to know about the process?
So I just put together this framework, and I'm going to see if I can share it with you here, kind of see it a little bit. So this really represents to me like how to fully encompass planning when you have minor children. So if you look in the center, you have your assets and your property, you have your kids here, and you have incapacity. To be able to care for that, you're going to do, for at least through us, a kid safeguard system, and that includes nominating guardians for short-term and long-term. Here, this is probably backwards now that I think about it, advanced healthcare directive, power of attorney, and HIPAA authorization. So those are planning for incapacity, right? If something happened to you and you were unable to make healthcare decisions, you should have somebody identified as an agent to be able to make those decisions for you, somebody that you know would make the decisions that you would want, okay? And then the last one over here is the revocable living trust, and that's going to care for your assets as well as identifying how you would want money distributed to your kids or assets. And around this, we have planning, protection, and peace of mind, which is what you get by doing all of this within the circle. Okay. So I also mentioned the kid safeguard system. So for our practice, we have a kid safeguard system. This comes standard with every trust package that we do for families. We also sell it separately because I know some families, they can't afford to do wills or trust-based planning. So we do these for families. And what our kid safeguard system includes is we have long-term guardian nominations, short-term guardian nominations. We also do letters to the guardians so that, I tell clients, don't use this.
How do you notify them?
Yeah. I say don't do this as the first means of communication of asking them, but it just says basically, hey, you're a potential guardian. If you have any questions, let us know. Also included, we have an exclusion letter. So maybe there's somebody that, if something were to happen and you have your guardians identified, maybe there's somebody that would petition the court to try and get custody of your kids, even though they're not listed as a guardian. So you can actually write a letter, and we include that here in this package that we do, that basically says, if it ever came about and they petitioned the court, here's this letter, and it's going to be in my stuff that says personal and confidential. Only if this person tried to get custody of my children would this go to the judge, right?
Yep.
And this is your voice when you have no voice.
That kind of gives me the chills.
I know. Sometimes my talks do. I'm sorry.
No, it's okay. I mean, it's the stuff that you don't want to think about, but you need to think about it.
Yeah. Another thing, too, I'll mention from a guardianship perspective that we do for clients is when you have guardians that you nominate, I definitely recommend nominating one primary and then two alternates. Because, what if you're in a car with the person that you chosen as guardian? Right. You don't have anybody with a backup. So make sure you list a few alternates as guardians. And then in addition to that, in your guardian documentation, you can actually state, if, let's say you had your sister and your brother-in-law nominated as guardians, right? But what if your sister was in the car with you? Well, your brother-in-law is listed as the guardian, so would you want him to raise your children by himself?
Right.
So you can literally write in here, okay for sister, but not okay for brother-in-law alone, and then it would go to the alternate. So you can get very specific in the drafting, and that's what we do for clients, is really ask those questions like, would you be okay with that? And a lot of times, no. The answer is no, they wouldn't be. We also do emergency information. People just don't think about, if you go on a date with your spouse and you leave the kids with the babysitter, does the babysitter know anybody's phone number except the spouse, besides you and your spouse? So this gives all of that information of people to call in case there's an emergency. we have emergency instructions and then just instructions to the guardian. So, you know, how do you want your kids raised if something were to happen? What school do you want them to go to? What church? What sports? Do you want them to travel? You know, play music, be involved with family members' lives. So it's really like those instructions that you're providing on how you would want your children to be raised. We also include this wallet card that basically you would keep in your wallet or your purse that says, you know, I have minor children that are depending on me. These are the people
all
that you
things
should
that like I wouldn't even think of, but yeah, it makes sense.
And then this is my favorite. This is the car seat sticker that we have. So if you have minor kids that, let's say they're infants, right, or toddlers, are they going to be able to communicate their information to emergency responders if there was a car accident? So you put this on the side of the car seat. It has the child's information. It has parents' information, emergency contacts. Emergency responders, at least here, look for this and look on the side of the car seat sticker. They'll take out their phone and they'll take a picture, or they'll take the car seat out and literally take it to the hospital. And so this sticker, you know, gives that information, especially if it's a toddler or younger and they can't communicate any information. So that's our Kids Safeguard system. And so this is really kind of what, you know, our real big focus is on with families when they have minor children, and making sure that, you know, the kids are protected. And that's what's important.
And it's awesome to know that that's an option if, you know, the entire package is outside of something that's affordable. Like, that's the priority, right? Is making sure your kids are protected and taken care of.
Exactly.
Well, I really, really appreciate you taking the time to do this. For those who are just joining or who didn't catch the whole thing, I'm going to save it. It'll be live in my stories for the next 24 hours. And I'm also going to get links so you can reach out to Krista if you have more questions, and I'll put it into a blog post so you guys can access it forever. And again, thank you so much. If you guys have more questions for Krista, you can find her at Estate Planning Mom. And I hope you guys all have a great afternoon.
Thank you.
Thank you.
Bye.
Bye.